Well, hello everybody. I'm Professor David Cantor, and as Director of the Refugee Law Initiative, it's my great pleasure to welcome you all to this 12th Annual Refugee Law Initiative Seminar Series, run this year in partnership with the University of London Refugee Law Clinic. This series of 6 webinars delves into the topic of asylum after COVID-19, looking at the UK's new plan for immigration in global context. Our objective is to interrogate how, as the global COVID-19 pandemic begins to slow, states and other actors are re-engaging with the issue of asylum. Each session in this series thus evaluates distinct aspects of the UK's so-called new plan for immigration in detail and by putting it in the context of broader global trends too. In this second session, titled Transforming Refugee Status, we look in more detail at how the UK's new plan for immigration engages specifically with refugee definitions and discrimination. Some countries have adopted statutory interpretations of the refugee definition in Article 1A2 of the Refugee Convention, but the new plan for immigration is the first attempt to do so in UK law. Likewise, the UK is one of only a few countries to try and make a two-tier system of rights for those entitled to refugee status, based on how the refugee entered the country. These proposed measures are found currently in the 2021 Borders and Nationality Bill, which is currently being debated by Parliament. These aspects of the new bill raise a number of important questions, including what statutory interpretation will the UK adopt to evaluate whether an asylum seeker has a well-founded fear of persecution? And how does this compare to existing approaches in the UK and in other countries? Can the UK legally justify creating a two-tier system that discriminates between refugees purely based on the mode of entry to the country? And if adopted, what effects will the proposed changes to the substance of refugee status have on the protection of refugees in the UK and beyond? To help us understand these proposals and their implications for the UK and the global refugee regime, we're really fortunate in this seminar to be joined by 4 expert discussants. I'll introduce each of them in turn before they speak. In terms of format though, we'll start off with a presentation from a Refugee Law Clinic volunteer describing the main pertinent features of the proposed new measures in the 2021 Borders Bill. Each of the 4 panellists will then briefly present their initial thoughts on a particular aspect of those proposals. After that, we'll open to a wider discussion format where the panellists can engage with one another and with questions and comments from other participants in the session. As such, during the initial presentations by panellists, please do pose your questions by typing them into the chat box. Finally, please do keep your microphones on mute and your videos off unless you're a presenter. We will also be recording this session, the podcast of which is available in the coming weeks on the RLI website. So without further ado, let me turn to our first speaker. This is Ram Sabaratnam, a UCL law student and Refugee Law Clinic volunteer lawyer, who will introduce some of the main clauses of the 2021 bill that seek to alter the nature of refugee status and how it's defined. Over to you, Ram.
Thanks, David. So in today's session on discrimination and definitions, we'll focus on 2 sets of provisions in the new Nationality and Borders Bill, and I'm going to summarize that for the benefit of anyone new to this debate and before our speakers offer their expert insights on the proposal. So the first clause is clause 10, and it's one of the most far-reaching changes envisaged in the bill, and it involves the creation of an arguably discriminatory 2-tiered system of refugees based on their mode of entry into the country. So clause 10 draws a distinction between group 1 and group 2 refugees. Group 1 refugees are defined by the bill as those who come to the UK directly from a country where their life or freedom was threatened and present themselves without delay to the authorities. Group 2 refugees are those who have not complied with such requirements. Clause 10 then gives examples of ways the Secretary of State would be empowered to treat Group 1 and Group 2 refugees differentially, such as in the duration of their permission to remain in the UK, the availability of routes to settlement, the ability to have recourse to public funds, and the ability of family members to join them in the UK. The purpose of this clause is apparently to discourage asylum seekers from traveling to the UK other than via safe and legal routes. And you can see that in the explanatory notes to the bill. Clauses 27 to 35 address the issue of definitions. And according to Article 1A, subsection 2 of the 1951 Refugee Convention, the term refugee applies to any person outside their country due to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion. Clauses 27 to 35 of the bill attempt to fix and in many cases narrow how the convention definition of a refugee is interpreted in UK law. So for example, Clause 28 adopts the EU Qualification Directive's particular approach to defining persecution by reference to the concept of basic human rights. Clause 29 creates an opaque and complex three-stage test for assessing whether a refugee does indeed have a well-founded fear of persecution. Clause 30 narrows the approach to defining the particular social group ground for refugee status. Clause 32 narrows the consideration of internal relocation alternatives by requiring decision makers to ignore any technical obstacles to return. And Clause 33 expands the evaluation of activities for which a refugee can be excluded from refugee status under Article 1F of the Convention. That was a mouthful. I hope this brief introduction basically just gives you a clear sense of the legal difficulties posed for refugee protection by clauses of the bill that are concerned with discrimination and definition. So on to our expert speakers now.
Many thanks indeed, Ram. So that gives you all a brief overview of the two main areas of the bill that we're going to be looking at, Clause 10 on the two-tier system and clauses 27 through to 35 on refugee definitions. And for anybody who wants to look at that in more detail, I hope you can access the PDF of the bill as introduced, which is in the chat function now. We turn now to our four expert presenters, and it gives me great pleasure to first of all introduce Dr. Hugo Storey from the International Association of Refugee and Migration Judges. I'll shortly be posting his bio in the chat too. Over to you, Hugo, for the first intervention.
Thank you, David. My brief is to focus on the bill's attempt to codify elements of the refugee definition set out in Article 1A2 of the 1951 Convention, Clause 29 on well-founded fear in particular. And of these clauses, Clause 29 poses for me by far the greatest threat. Unlike the others, it's brand new. When I say brand new, of course, I only mean to northern shores because it is borrowed, as so much else in this bill, from Australian legislation, in particular, Section 5J of their Migration Act. It's my view that if this clause goes through as it is, it will press gang judges in the UK into having to interpret the Refugee Convention in a way contrary to the uniform international meaning that the UK senior judiciary has so jealously sought to uphold over the past 25 years. It will also be completely counterproductive, as it will lead to endless litigation. If you look at the various statements about this clause made in parliamentary committee by government figures, you enter a world of double speak. Tom Pursglove says the clause is needed to achieve clarity. What he means by clarity, decoded, is that the government does not like the existing case law. UK case law on well-founded fear does not lack clarity. How many decisions can you think of that raise an issue about well-founded fear in recent years? Pursglove talks about the importance of a holistic approach, but Clause 29 expressly prevents a holistic approach. Presently, decision makers consider past, present, and future circumstances holistically and apply to them the same standard of reasonable likelihood or real risk. presently, under the approach of the Court of Appeal in Quran, the assessment of future risk keeps everything on the table and asks in relation to past facts whether they are likely to help the story, except for the impossible or the remotely unlikely. But clause 29 is drafted so that there are two preconditions. So you don't get to be considered holistically as to reasonable likelihood of being persecuted on return unless you've met both of these preconditions. So there's a precondition which is a reasons-related precondition, and there's a precondition about fear. So if the decision maker decides that you have only established that you left Eritrea illegally to a 49% likelihood or less, that's it. You never get to have any holistic assessment. Even if the decision maker thinks in terms of future risk, you are 90 or 100% likely to be at risk. It seems highly likely that the aim of the fear precondition is to reintroduce the test of subjective fear, or fear as trepidation, a test which our case law has long rejected. By limiting itself to fear rather than well-founded fear, this precondition will mean endless reventilation of issues before courts and the tribunals about whether subjective fear can be a necessary requirement in the case of a young child or a mentally disabled person or a brave or a foolhardy person, and will force everyone to have to try and create a battery of artificial procedural devices to overcome the blatant inefficacy of such a test. So for me, from the decision-making perspective, trying to get the government to abandon clause 29 should be a top priority. With the House of Commons committee stage finishing tomorrow, the House of Lords looks like the only real hope. I don't have time in my talk to develop the argument, but from a drafting point of view, clause 29 is extremely problematic. Just to give you two examples, it appears to want the fear test to be confined to whether or not there's been past persecution, but its wording is in the present tense, and so does not actually exclude forward-looking assessment. But even if it were somehow understood as being about past persecution, then it would make it impossible for anyone to establish, for example, a surplus claim based on activities since they left their country of origin. So that's all from me. Thank you, David.
Well, thanks, Hugo, indeed, for that particularly detailed analysis of clause 29 as being a real threat, I think, to the refugee definition and the way that that's interpreted in the UK. Of course, that's not the only issue that is live with the bill at the moment. And for some further comment around this issue, I'd like to turn next to our second distinguished speaker, Professor Elspeth Guild from the School of Law, Queen Mary University of London. I shall post her bio in the chat function in just one moment, but Elspeth, over to you, please.
Thank you so much, David. And thank you so much to Ram for your presentation of the issues that we're looking at out of the bill today. And Hugo, to your very impressive and persuasive argument about clause 29, which I agree entirely with. I'm going to go back to clause 10 and talk a little bit about discrimination in my 5 minutes. And as we know, clause 10 creates, as Ram has explained to us, these class 1 and group 1 and group 2 refugees. Now, this is a very innovative way of looking at the Refugee Convention. And I would refer everyone not only to the absolutely marvelous series of blogs which RLI ran on the consultation paper, which morphed into the bill through a rather inelegant reluctance of the government to wait for the end of the consultation to table the bill. But also I would very strongly recommend anyone who's interested in this subject to look at the UNHCR detailed notes on the bill. And I think that it is an indication of just what a challenge this bill is to the current status of international refugee law, that UNHCR would produce almost 100 pages of very, very detailed commentary on every provision of the bill, almost all of it unequivocally negative. But if we go back to our groups 1 and 2, who is a deserving refugee who has arrived by some kind of regular route? Who is an undeserving refugee who has arrived by some other route? The division of these two groups on the basis of how someone's arrived in the UK is a profound challenge to the principle of non-discrimination in the Refugee Convention itself, also in international law. Until now, I am not aware, there may indeed be examples, but I'm not aware of any examples where a state has determined that someone is a refugee, fulfills the definition, with all the caveats that Hugo has mentioned about the definition and the attempt to hijack from international law, and indeed from long-standing case law of the British judiciary, the question of interpretation. But the idea that you could have two groups of people who were recognized as refugees who would be differentiated, and one group would be discriminated against in terms of course, the four main issues which always interest the British government in terms of immigration and reducing what they consider to be the two generous aspects of British immigration law, which is duration, settlement, access to public funds, and family reunification. Of course, for refugees, family reunification is one of the keys. Only in July 2021, the European Court of Human Rights, in a case called MA versus Denmark, had to consider whether differential treatment on family reunification for beneficiaries of subsidiary protection from refugees was lawful or not. And I think a number of us were quite disappointed that the Court of Human Rights, and it was a Grand Chamber judgment at paragraph 177, refused to engage with the question about whether differential treatment between beneficiaries of international protection and refugees as regards family reunification constituted discrimination. It accepted what I think many observers and legal experts in the international refugee law world consider, that these two categories are ones which are, in respect of which the principle of discrimination does apply. They are not so different that the principle of discrimination does not apply. The UK has gone one step further here in saying that it will treat different classes of refugees, create two different classes of refugees, and extend the argument made in MA versus Denmark to say that these two classes are so fundamentally different that discrimination does not apply. Their situations are not different and therefore cannot be compared. And I think that is a tremendous challenge to international refugee law. And I'll stop there. Thank you very much, David.
Excellent, many thanks, Elspeth. And I think the point that you bring across of this attempt to introduce what looks like discrimination, even by reference to some relatively flexible human rights standards on point, is a key consideration, hopefully something we can debate a little bit further as we continue. I'd like to turn now to our third speaker. I'm delighted to welcome Colin Yeo, barrister of Garden Court Chambers and known to many of you, I'm sure, as well as the author of the Free Movement blog. Over to you, Colin.
Thanks very much, David, and thank you very much for the invitation to participate as well. Talking about Clause 10, I've been asked to focus on the potential legal and practical implications of the proposal to create this two-tier system of refugee status. I think it's important to note that the distinction between these Group 1 refugees and Group 2 refugees is, on the face of it, at least purportedly, based on the wording of the Refugee Convention itself. which is quite a clever move by the government if you're trying to insulate yourself against potential legal challenge. So a Group 1 refugee came to the UK directly from a country or territory where their life or freedom was threatened in the sense of Article 31 of the Refugee Convention, presented themselves without delay to the authorities, and where they're already in the UK, but unlawfully, they must also show good cause for that unlawful entry or presence. And you'll recognise that language as being derived from the Refugee Convention itself at Article 31. That's not the whole of it, though. This scheme of a sort of two-tier system isn't confined only to Clause 10 of the legislation. It kind of permeates a lot of the asylum provisions. For example, clauses 11 and 15 on asylum accommodation, clauses 13, 14, 15 on the admissibility process, clause 26 and schedule 3 on offshore processing, which may prove to be illusory if no agreement can be reached with another country, and importantly, clause 37, which criminalizes arrival without authorization. And this kind of two-tier system appears in all of those places. As I think has already been touched on, the specific forms of discrimination which are cited in clause 10 as it's currently drafted, and it's gone through committee intact, I think, are about the length of leave that is granted to a refugee, the conditions for qualifying for settlement, access to public funds and family reunion. And one of the strange things that I really struggle to get my head around with this, because I can't see into the future, is really why the UK government is actually passing this legislation, because it's a permissive power. It doesn't require discrimination on this basis. It just allows it. But anybody who's familiar with UK immigration law will realise that these changes could be implemented without primary legislation in any event. They might be more susceptible to challenge, but I'm not sure that necessarily turns out to be the case, because one of the things that's notable is that the existing partial incorporation of the Refugee Convention into British law at Section 2 of the 1993 legislation, which prevents the immigration rules from doing anything not in compliance with the Refugee Convention, that's not been done away with. It's going to be there. So if immigration rules are introduced which refer to these permissive powers, they still can't, they're still not allowed under Section 2 of the 93 Act to breach the Refugee Convention. And people who've read beyond, the Article 1, Article 31 of the Refugee Convention will be familiar with, for example, Article 34 on the duty to facilitate the assimilation and naturalization of refugees, which arguably the limitations on settlement would violate. And also Article 23 on access to public relief on the same basis as nationals, which again, the prohibition on access to public funds would appear on the face of it to contravene. But the thing, I'm going to leave you with this, the thing that I really can't get my head around, as I said, is whether this is simply theatre, legislative theatre, as if the government looks like it's giving itself these powers, or whether it's actually going to go ahead and use these powers. And I think we can see that as well in other bits of the Act, for example, on maritime pushback powers. It's hard to know whether the government's kind of signalling an intention, which it will never actually follow through on, or whether it is quite serious and it is going to act fairly transparently in breach of various different articles of the convention. And I'll leave you with that thought.
It's certainly an intriguing thought. So many thanks for that presentation, Colin, and for talking us through some of these perhaps paradoxes in a way between the apparent illegality or difficulty in practical implementation of some of the provisions and the determination apparently politically to see them through. We come on finally to our last speaker, but before turning to her, I'd just like to remind you that you are, of course, very welcome to type questions and comments, as some of you have started to do, in the chat function. We should have good 20 or 30 minutes after the speakers to talk through some of the questions and issues that have been raised so far. So without further ado then, let me turn to our final expert speaker for today, and it gives me really great pleasure to welcome back to the RLI Dr. Maria O'Sullivan from the Law Faculty of Monash University. Thank you for joining us at a time that I'm sure is extremely inconvenient for you, as I know you're calling in from Australia, but we really appreciate you being here. So you have the floor.
Thank you, David. So everyone, the situation in Australia is quite complex, but I'm going to flag a couple of key points. Firstly, we don't have a National Bill of Rights in Australia, and neither, of course, are we party to a regional instrument. So that's the first major difference. The second thing I want to point out is that with the two-tier system in Australia, it's almost 3 tiers, actually. We have the emphasis on resettlement. So back in 2012, one of the most important documents was a national panel, an expert panel it was called, where it said that resettlement is the orderly, proper way for people to come and seek asylum in Australia. That's always been the case, but it was very much encapsulated in this report. And it's almost using that queue mentality. If we have a generous resettlement policy, which is around 13,000, then the argument is people shouldn't use spontaneous arrivals. So resettlement is at the heart of this. The two-tier system happens when people spontaneously arrive. If they do arrive on a plane with a visa, then they are treated to a gold class sort of standard in terms of merits review, protection visas, etc. But the very much needy cohort, which tends in Australia to be from Afghanistan, Iraq, and Iran, they come on a boat, and we all know why, because they can't get a visa to come to Australia. And then there are a number of obstacles they face. They can't by right apply for a refugee visa. They have to get permission from the Minister for Immigration to do that. We call that a bar on asylum processing. Then if they do get their refugee application approved, and that's difficult because there's a fast track system in place for boat arrivals, they do get it approved, they only get a temporary protection visa. That is for a period of 3 years. And very controversially, since 2008, that's what we call a rolling temporary protection visa. That is, that can never turn into a permanent protection visa. The old sort of version, there's 2 versions, pre-2008, they could do that. And as a lot of speakers have already talked about, one of the primary obstacles is family reunification. So people who arrive on a boat without a visa and who get this temporary protection visa cannot get family reunification. Now, they do get work rights, and this is where I'd like to pick up on what Colin said about Article 34, because obviously if you've got a rolling temporary protection visa scheme and people are here for 6 to 7 years, they do integrate into the Australian community. And if they integrate in rural areas where they have skills that are needed, and typically that's been in things like abattoirs, funnily enough, the community sometimes oppose the deportation of those people because they are needed in that rural setting. So look, Article 34 is interesting in terms of temporary protection visas in Australia. It's not able to be directly litigated because we haven't domestically implemented all of the convention. But I think it is something on a policy basis that is very important. So I hope that gives you a flavour of the Australian policy, and I'm happy to talk more in chat or discussion.
Fantastic. Many thanks indeed, Maria, for the view, as it were, from Australia. As a number of the speakers have noted, there are a lot of the more restrictive measures in the bill, and indeed even the idea that we are going to increase our resettlement quota seems to be modelled to some extent on the Australian system. And some of the provisions are directly carbon copies of that as well. So we have an opportunity now for a bit more free-ranging discussion. I'm really, really grateful to all 5 of our speakers, including Ram, for keeping so well to time. I know how difficult it is to present a key set of thoughts on such a such an intriguing piece of legislation such as this one, raising so many political and legal issues within such a short space of time. I can see that we're starting to get a number of comments and questions in the chat, so please do continue to add those. But I thought for the first round of questions, I'd give each of the 4 expert speakers in turn a chance to respond to anything that they've heard others say or points raised in the chat that they might like to respond to. And whilst thinking about that, perhaps just an extra question from me as chair, if I can abuse that position just for one moment. I wondered what the view of the panelists was on whether these proposals or these proposed provisions make the UK an outlier in terms of the way that its refugee law is going, or whether they reflect broader trends in national refugee law elsewhere. And I suppose part two of my question, which is slightly related to that as well, is do you think that the UK government is trying to send a message? I mean, clearly there's a message which is intended for those who might claim asylum in the UK, but is there a message that's being sent, do you think, to other states who may be hosting refugees, developing refugee law, etc., whether that's Australia or more broadly? So where does this sit in the kind of international relations, international politics of the refugee regime? And Elspeth in particular, what might this tell us about what we think about things like the Global Compact on refugees, which try actually, I think, to do something rather different to what this bill is doing? So having posed a couple of questions and given a little bit more time for a few more questions in the chat, I'm going to go in order of the speakers. So Hugo, can I give you 2 minutes to pick a question or two and respond to that, please?
Sure, David. I've spotted 3 questions. One was an anonymous one asking, wasn't the suggestion that there'd be a different standard of proof in relation to future risk rejected? Not to my knowledge, not up to the beginning of this week, and the specific amendments were rejected. Maria posed a question about, could I say something about clause 31.1 about non-state actors? And I thought that was interesting because if we were talking about the EU qualification directive, the general answer would be, well, yes, it does allow non-state actors of protection, but under extremely rigorous qualifications. Essentially, a non-state actor would have to meet 5 qualities: ability, unwillingness, accessibility, durability, and effectiveness. But it's interesting when you flagged up what the Australian legislation says, Maria, because looking at that, the Australian legislation does at least mention durability and accessibility, whereas the clause 31.1 essentially strips it down to ability and effectiveness. So I think that is a worry, but perhaps also illustrates that even as dire as the Australians see the Australian Migration Act, it still got some features, and the same also applies to a particular social group, where the approach is taken as it's an alternative rather than the cumulative test. Just in terms of David's question very quickly, and I'll stick just to the first part, is the UK an outlier? I think we've got to bear in mind that already by not signing up to the qualification directive recast, the UK had already started to veer away from European standards, and that's very evident, for example, in the provisions relating to internal protection. So I think we've already become something of an outlier, and certainly in terms of the refugee definition, I think you can't really find very many examples outside the UK and Australia, if this bill goes through, that diverge from the body of case law and international standards that's been built up.
Many thanks indeed, Hugo. I can see that there are other questions coming along even as you're talking, so we may hopefully at the end have time for a second round. So do everybody keep your eye on the chat box. Elspeth, can I turn to you and ask the same, if you wouldn't mind picking a couple of questions and giving us your thoughts on those, please?
Yes, I think that there's one thing that I think is of paramount importance in respect of this bill as a slap in the face to international refugee law and international human rights law, and to the UK's very vocal support of the Global Compact for safe, orderly and regular migration, which is founded not just on human rights, but also on the principle of non-discrimination, is this attempt to insert into primary legislation discrimination between persons in the same class. So refugees 1 and refugees 2 are discriminated against in very profound areas of life, family reunification, settlement, etc. We've talked about all of them. That is an unprecedented move. It is a it is very much against the direction of movement in respect of the UN Convention on the Elimination of All Forms of Discrimination, against the Global Compact on Migration, and questionable in the context of a case which is currently pending before the International Court of Justice, which is Qatar versus UAE, on discrimination of collective expulsion on the basis of nationality. So we are at a real threshold at the moment on this question of what does discrimination mean in the context of immigration status and nationality. And the UK is leading one particular pact to say this can never be discrimination.
Very interesting. Many thanks, Elspeth. I think this point about discrimination is just so key, and clause 10 and the other provisions that Colin mentioned that kind of derive from that fundamental distinction are really very, very troubling. I've posted some of the RLI's comments on clause 10 in the chat function for those who are keen to look, but Elspeth, I think you've really put your finger on the pulse of exactly what is concerning about that. So thank you very much. Colin, can I ask the same? A couple of minutes of comments on some of the questions?
Yeah, so I'd say one of the striking things I think about the legislation is that it includes powers to do things, but it doesn't require them. I'm sort of repeating what I said earlier to an extent, but for example, if we look at clause 10, it reads subclause 5, the Secretary of State or an immigration officer may treat group 1 and group 2 refugees differently, for example, in respect of. And it's may and for example. So the minister in the discussion on this clause during the committee, I've posted a link to that in the chat, and also the quote, talks about this as a non-exhaustive list and says that they might not use it in appropriate cases. So this isn't actually as such embedding discrimination. Now that's there's maybe a slightly overly fussy approach to things. It's the power to discriminate. But I think that the UK government has so much control over the immigration rules, but by means of introducing them via this very light scrutiny process, negative resolution process through Parliament, via the immigration rules, that it could have done a lot of this anyway. And for example, we see safe return reviews, as they were called, introduced 2015, I think it was, under Theresa May, when she was Home Secretary. And the reality on the ground is that there's a policy that describes these, but they don't happen in real life. They don't happen in practice because it's extra work for the Home Office when they're already overwhelmed by their own inefficiency, and we can see asylum waiting times going up and up. So I query whether this is actually going to lead to these kinds of things being implemented. And there is a legal bar to this being implemented by the immigration rules, which is that it remains arguable if it's done via the immigration rules, which it would still have to be because this is a permissive power. It's still arguable that that would be incompatible with the Refugee Convention in reliance on Section 2 of the 93 legislation, which prevents the immigration rules from contradicting the Refugee Convention. So it's a really curious way of doing this, which almost designed to invite a legal challenge if they do actually follow through. And that's not to say that this is response to one of the questions to me in the chat. That's not to say that judges can overrule or go behind primary legislation. They can't, but they can look at the way that discretion under primary legislation has been exercised. That is something that's a bit more amenable to review. So yeah, I'd be very interested to see how this pans out. And the fact is that this is going to go through in its unamended form. The government is going to introduce this legislation, but what it then does after that seems a bit of a mystery, frankly.
Many thanks, Colin. And you finished, I think, on the point of discretion. I think there's something quite interesting there in clause 10 itself, which is that it's not clear whether or not these differentiating measures will be applied on a group basis, in other words, to all group 1 refugees as opposed to group 2 refugees, or on an individual basis to some Group 1 refugees, but not, or some Group 2 refugees, but not other Group 2 refugees. So the question there about how discretion is exercised and how wide that discretion is, I think is a really crucial one to interrogate further. I'd be keen in the second round of questions to hear a little bit of your thoughts and those of other panelists on that too. Thanks very much again. Maria, can I call on you to respond to some of the many questions that are now appearing?
As to the outlier issue, I think Australia, first of all, wants to be an outlier in this area. And of course, we can sort of push like our views on other countries. For example, the whole reason that we negotiated an agreement with Nauru is we had economic power over Nauru and Nauru needed us. So we're in a slightly different geographically and you know, socially geographical area, I guess. It's just interesting in terms of how practices are copied, because my understanding is that the pushbacks and offshore processing that Australia used actually mimicked what the US was doing in the Caribbean environment, so the so-called Caribbean solution and the SAIL decision. So we've sort of brought that on, and then we've amplified it and solidified it in legislation, and then other other countries like Denmark and the UK want to copy that. I haven't talked about offshore processing. I think that's more complicated, but I'm happy to do that in chats. One of the things is that the deterrent policy related to this issue is very much front and center in Australia. So that is, we have advertising campaigns that we publicize in Indonesia, Pakistan, Malaysia, saying that if you come to Australia on a boat without a visa, you'll be detained. You will get temporary protection only. You know, you'll be sent to an offshore processing. So all those restrictions that we have, and the two-tier system is very much sold in those countries, so people don't come on a boat. And just lastly, in terms of discretion, I know I'm jumping ahead, but discretion is an odd thing in Australia because we have very strict criteria about Group 1 and Group 2. So if you're an unauthorised maritime arrival, that's it. You are subject to detention, and there is no mixing between the two. The only way an individual can be given some sort of humanitarian help is that if they apply directly to the minister and seek his or her humanitarian protection, and it's very much a personal power, it's non-compellable, and it's not subject to judicial review.
Right, many thanks. And I think, Maria, you know, the example that you give of Australia is so valuable in so many ways. I mean, this question that you've raised, which other panelists might want to come back on in the second round of questions about, you know, how do these kind of new developments in refugee law occur? You know, and as you've rightly pointed out, you know, one state does something, another state copies it, but, you know, adds a twist to it, a third state copies it and adds, you know, it's a sort of Chinese whispers kind of game in some of these circumstances. But it raises serious questions about, you know, how do states get their inspiration for how they respond to refugee situations, and you know, particularly how they try and limit their refugee responsibilities, I suppose. The Australian case, I think, also raises some very interesting questions that you've kind of alluded to, which is, you know, Australia sort of balances some of the more narrow interpretations and more restrictive measures that it has, at least in principle, with a more generous resettlement program. And so, you know, the idea is, you know, it's pretty much, you've got a fairly clearly defined good refugee and bad refugee, depending how they come to the country, more or less. And, you know, that's certainly there in the new plan for immigration that the UK government's put forward, this idea we are going to upscale our resettlement schemes. I haven't heard a great deal more about that, but it may be that panelists sitting today have indeed heard more announcements about what form this is going to take, how many cases we're looking to include, etc. I mean, are these more restrictive measures that are being pulled from the Australian model being balanced by something else that shows a shift towards a more Australian type model, albeit in a different regional context? Or are we just kind of picking all the bad stuff and leaving it at that? So I think there are really a number of questions around that. I can see that we've got a whole set of chats going on here, and I'd like to give panelists the chance to keep responding to questions and comments that are raised by other panelists and also by other participants in the chat function. In this second round of questions, though, I wonder if, looking particularly at the UK system, and Maria, I suppose, thinking about, what's happened in Australia in your case, what do we think the systemic impact, if adopted, of these proposed clauses would be? I mean, Hugo, you've talked very briefly about the fact that you think, for example, the three-stage well-founded fear test would have a major impact on the system. I mean, what would that look like, do you think? What would the definitional tweaking mean for the system of asylum as a whole in the UK? And I think, Elspeth, you might want to come in on that. And Colin, you've talked quite a lot already about, has the UK Home Office really got the capacity to implement provisions like Clause 10? Well, if so, then what? But if not, then where does that really leave all of these measures? So we've got probably 10 minutes to talk through that. So Hugo, can I go to you for another 2 minutes on that question and others that seem to be coming up in the chat function, please?
Okay, I mean, on your systemic impact question, David, I'm not sure I've got much to say just now, but in terms of the questions I've seen on the chat, James McGovern asked one about whether the two-stage test in Clause 29 would disproportionately affect children and persons with disabilities. And I think the answer to that is clearly yes. And given the discussion of the Australian model, I think it's interesting because as I understand it, the Australian model doesn't prevent, when judges are looking at future risk, doesn't stop them from keeping everything on the table, to use the language I adopted earlier. Whereas Clause 29 does, it creates these preconditions or hurdles, as James described it. There was a question about whether there's already a more restrictive definition of a particular social group in the UK, and I think there the answer has to be yes. There were some obiter comments by the late Lord Bingham in Fauna and one or two upper tribunal cases, but at the moment there's something called EU retained law, and the Court of Justice has said that the two different requirements for a particular social group are cumulative. I mean, the only other thing I just want to say, and it goes to the point that Colin raised about the survival of Section 2 of the 1993 Act. I think, at the end of the day, the UK is a dualist system. If you look, for example, at the Assange case in the Supreme Court, you'll see there the problem that on the one hand, there's a presumption that the UK seeks to keep within its international obligations. On the other hand, there's a presumption that the UK government legislates to be in accordance with the international standards. And it doesn't leave judges much leeway. That is why I said that I think judges are going to be forced to have to make decisions where they say, this deviates from the internationally accepted meaning, but I have to apply the law.
Thank you, Hugo. Elspeth.
Well, I was just having a quick look at Erskine and May, because ever since they put Erskine and May, the Bible of Parliament, online, you can now actually search it and it's free, and it's a wonderful source. Because I had thought there was a convention that Parliament should not legislate to overturn Supreme Court or House of Lords, as it would then have been, decisions directly. But I couldn't find it. That's partly because the search engine for Erskine and May seems to be highly inadequate. So I think I'll make a complaint to them. But I'd be very interested to know if anybody else can remember this and thinks there is any such convention. Because if so, the courts then will have to also deal with that question about the legitimacy of overturning so many Supreme Court judgments all at once in one bill. It seems quite an extraordinary way of proceeding with a piece of legislation.
Fantastic point. If anybody can help us, chat functions there. Otherwise, I think that's a good topic for a MA dissertation for any of those who are looking to write one of those fairly soon. Really great point. Thank you very much, Elspeth. Colin, over to you.
David, you asked about whether powers, the discriminatory powers might be used on a group basis. I just don't know the answer to that. And I can see, looking through the minister's comments on criminal offences, which is a slightly different but related issue, that quite surprisingly, this general offence of arriving without prior permission won't be applied universally. And they're quite clear about that. It would lead to thousands and thousands of people being prosecuted and imprisoned every year. They just don't have the prison places for it, apart from anything. But they, if I just read out a quick bit, we will be targeting for prosecution those migrants in cases where there are aggravating factors, where they cause danger to themselves or others, including rescuers, where they cause severe disruption to services such as shipping routes, or the closure of the Channel Tunnel, or they're criminals who have previously been deported, and things like that. But it's easier to see individual discretion being used in prosecution cases where you've got the CPS involved, the Crown Prosecution Service, having to make a decision, as opposed to application of the immigration rules, where it seems unlikely that it will be left to individual caseworkers to make judgment calls like that. It will probably be done on a group basis, I would guess. About picking the bad stuff from the Australian model, and the thing that comes to mind, and I'm sort of sorry for saying this, it's kind of a bit studenty, but the quote from Marx about the first time as tragedy and the second time as farce comes to mind with the Australian model. Because if you look at things like the pushback powers that the government is taking on quite subtly through one of the schedules to this legislation, the powers as they were exercised by the United States in the Caribbean, as they've been exercised by Australia in the ocean around that country, it always involves taking people somewhere. You've got to have either the agreement of that country or it's direct refoulement in the case of the US, or it's a sort of safe third country in the case of Australia. And whether it's really safe is another matter, but that's the principle of it. Whereas with the UK, we don't have any agreements with third countries. And at the moment, the proposal seemed to be to push back into international waters and then leave them to drown, or maybe they'll have enough petrol to get back to France or something. And it's very hard to imagine that the government is serious about that, or would find people willing to implement that policy in practice. And so you see these kind of attempts to ape the kind of Australian model, but without any of the diplomatic clout or nous or negotiation skills that have gone with that could actually make it a reality as far as we can see. In terms of systemic impact, I'd be tempted to say none, because a lot of this just isn't going to have any effect. It's not really going to deter anybody from coming. There's no research that suggests that deterrent policies have any such effect. But I don't think it's quite fair to say none, because it might well not deter anybody from coming. That's not to say it won't make their lives miserable once they're here. And for example, the safe return reviews that we have at the end, at the moment, at the end of a 5-year period, that's something the Home Office has to initiate itself, and therefore there's a barrier to that happening. Whereas if you just grant short periods of leave repeatedly, some people will filter through the gaps. Essentially, they'll fail to make applications, and you'll just get rid of some people by default, effectively. And I think what we can foresee as an impact of this is a further growth in the size of the unauthorized population in the United Kingdom. As people will arrive, they'll be very badly treated, and they'll fall through the kind of legal, regular migration routes, and they won't leave the country. They won't be forced out. Enforced removals are even before the pandemic, we're at a historic low in this country, and so the size of the unauthorized population grows and grows, and the government then says that further strong measures are needed to deal with that, and those strong measures just make the problem worse, and there's this kind of vicious cycle going on.
It's a very apt description, Colin, thanks. And the idea of a vicious cycle of increasingly extreme measures that really don't do much but push the problem still further, make it still more irresolvable, seems, I think, really on point here. So thank you very much. Maria, you have the last word.
Yeah, I'd just like to bring up something Sarah Singer said about litigation, I think appeal rights, in tribunal courts. So one thing I flagged is that if you're a boat arrival and you arrive between 2013 and 15, I think it is, you only get a fast track procedure at the merits review level. So normally you go from the Department of Immigration to the Australian Appeals Tribunal and you get a rehearing. If you're a boat arrival, you get the department, but you are obliged to put all your evidence at the original decision maker level, and you can only go to this assessment authority if you've be reheard on the same material. You can't adduce new information unless you give a good reason for doing so, and you only get a decision on the papers. But the good thing about Australia, even though we don't have a Bill of Rights, we have a constitutionally protected High Court, and so judicial review can never be reviewed, although they have tried. And then just going back, I guess, to the role of the courts in Australia, we have a very robust administrative law system. So that has been really the engine room in protecting the human rights and refugee sort of rights of asylum seekers in Australia. So with the fast track system, that has been litigated a lot on unreasonableness and natural justice. And then finally, I think with pushbacks and offshore processing, one of the things that's not clear to people, I think, outside of Australia is that the legal complexity of the system we've built up means that the litigation that has occurred is quite staggering. The cost of operating those systems is also very high, and that goes back also to temporary protection visas. We've got to have an administrative structure which actually deals with all these visa processing. So if I was to sum up the Australian experience, I would say looking outside, people may think on paper that it works very well, and I'm talking about, you know, policymakers looking at Australia. But in fact, all the litigation that has occurred, there's been class actions from Nauru and Papua New Guinea. The government has had to settle in the billions of dollars. Operating Nauru and Papua New Guinea cost billions of dollars. And of course, the human cost of the uncertainty to people who are on those offshore processing centres and also on TPVs is extremely high.
Thanks, Maria. I mean, I think that you've ended on exactly the right note, you know, the cautionary tale of Australia, if you like. And I think what all panelists have done today is really, if you like, fired a warning shot across the bows of those who are considering this legislation. It's not just about the effect on refugees, which is a concern, but actually the effects more generally on the asylum system and the surrounding immigration systems, border control, etc., in countries like the UK. And my hope is that you know, this podcast will be watched many, many times, and that these points will not be proved to be as grim as we make them out, but they are certainly a real cause for concern. Talking about some of the issues that have been raised here, if you like, around the fringes, we will be looking in much more detail at different provisions of the bill and of the new plan for immigration in the coming sessions. For example, on the 9th of February, our 5th session looks at this question of international cooperation, things like offshore processing. We have a session, All Friends Together, ? International cooperation and the new bill. So do come along to hear what's said specifically around that point too. Otherwise, I should just say that it's been an excellent discussion, and I think that's probably all we've got time for. So allow me to draw the proceedings to a close by expressing my very great thanks to colleagues here at the RLI, Ram from the Refugee Law Clinic, and especially our 4 fantastic presenters today, and also for each one of you for participating remotely in today's session. We look forward to seeing all of you for our 3rd session in this series, which is called Moving the Goalposts, yet again, Access to Justice in the UK Asylum System, and that's going to take place on Wednesday, 8th of December at the same time. Full details are on the RLI website, and you'll see that one of our speakers there is UNHCR Assistant High Commissioner for Protection, Gillian Triggs, amongst all of the other amazing speakers that we have for that session. So thanks once again, and until then, goodbye everybody.